Stop what you're doing for 30 seconds, because the headline you're seeing about the Supreme Court ending carry bans nationwide is half right, half wrong, and that mistake could put you in real legal danger. Pause. The court has not erased every carry ban in America, but it is looking hard at one kind of sweeping rule that can turn a normal trip to a store, gas station, or restaurant into a criminal charge for a licensed gun owner. Pause. Quick question before we go any further. Are you subscribed yet? Because if you carry, travel, or even think about getting your permit, the update I'm about to break down could keep you from making a mistake that follows you for years. Hit that subscribe button right now and let's get into it. Here's what just happened. Back in 2022, the Supreme Court decided Bruen and said the Second Amendment protects carrying a handgun outside the home for self-defense. That was a huge deal. But after that ruling, several states did not just shrug and move on. They came back with new location bans and new rules about where permit holders could and could not carry. And one of the biggest new rules was this. Some states said that if private property is open to the public, like a grocery store, gas station, shopping center, or restaurant, you still cannot carry there unless the owner gives you a clear permission first. In Hawaii, that became the rule at the center of Wilford versus Lopez. Hawaii made it a crime for a permit holder to carry on private property open to the public without express authorization. In plain English, if the owner did not clearly say yes, the answer was treated like no. Now, this is where it gets interesting. Hawaii is not alone. 4 other states have had similar private property default rules in the post-Bruen fight: California, Maryland, New York, and New Jersey. So even though the case comes out of Hawaii, the impact could go way beyond Hawaii. The Supreme Court took that Hawaii case in October 2025. Then, in January 2026, the justices heard oral argument. And during that argument, several conservative justices sounded openly skeptical of Hawaii's rule. Chief Justice Roberts questioned why the Second Amendment should be treated like a disfavored right. Justice Alito pushed back on the idea that the state could reduce the right to carry to second-class status. Justice Kavanaugh said he did not see a broad enough historical tradition to support Hawaii's rule. And Justice Gorsuch hammered the state over its reliance on ugly old laws, including an 1865 Louisiana Black Code, to justify modern restrictions. That is why people are using urgent language right now. Not because the final opinion is already out. It is not. But because the court looks like it may be ready to say these broad, default no-carry rules go too far. Let me break that down for you with a real-world picture. Imagine you have a valid permit. You leave your house, stop for gas, walk into a convenience store, grab a drink, then head into a strip mall for dinner. Most people think, if I'm licensed, I'm fine, unless there's a posted sign. But under one of these broad default rules, that may not be true. Under that kind of law, silence from the business owner does not mean yes. Silence means no. And that's why some lawyers have mocked these laws as vampire rules. Like a vampire in an old movie, you need an invitation before you can come in. But here's the crazy part. The biggest danger right now is not only the law itself, it's confusion. Some people hear the Supreme Court heard the case and act like they already won. Other people hear there are bans everywhere and assume they can never carry anywhere. Both mistakes can get you in trouble. First thing you need to understand, a Supreme Court argument is not a final ruling. Second, even if the court strikes down Hawaii's private property rule, that does not automatically mean every gun restriction in every state disappears. Third, until the final opinion comes down, your local law still matters right now. If you're finding this helpful, imagine what you'll learn in my next video about the exact sentence that can stop you from talking too much during a gun-related police encounter. Subscribe now so you don't miss that one. Now, let's talk about the part nobody's talking about enough, the court split. Because this is why the Supreme Court stepped in. New York tried something similar after Bruen through its Concealed Carry Improvement Act. That law created a long list of so-called sensitive places, and also tried the same basic move on private property open to the public. If the owner did not clearly allow carry, then carry was treated like a crime. Gun owners challenged that law in Antoniuk. Here's what most people get wrong. They think Antoniuk gave us a nationwide Supreme Court answer. It didn't. In 2023, the Supreme Court turned away an emergency request to block New York's law while the case was still moving, but Justice Alito, joined by Justice Thomas, wrote separately and said, the New York law raised novel and serious questions. Later, the Second Circuit said the challengers were likely to win against New York's open to the public private property rule, meaning that part of the law looked unconstitutional. But in April 2025, the Supreme Court denied review in Antoniuk, so it still did not settle the issue for the whole country. That left the lower courts fighting it out, and then came the big split. On the very same day the Supreme Court heard the Hawaii case, the Fourth Circuit ruled in a Maryland case called Kipke v. Moore. And that court struck down Maryland's ban on carrying guns on private property open to the public, The judges said Maryland's rule was aimed at gun owners, not property owners. They said property owners already have the power to tell people with guns to leave. The state did not need a broad criminal law to do that for them. And the court warned that Maryland's rule would effectively make most public places gun-free zones. Read that again in plain English. One federal appeals court said this kind of rule is likely unconstitutional in New York. Another federal appeals court said it is unconstitutional in Maryland. But the Ninth Circuit upheld Hawaii's version. That split is exactly the kind of mess that pulls the Supreme Court in. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Here's a hypothetical example to explain this. Let's say you live in a state with one of these rules. You have your permit. You stop at a bakery in a privately owned shopping center. No sign says guns are banned. No employee says anything. Most gun owners would think that means they are okay. Under a broad default rule, they may not be. Under the logic favored by the challengers, they should be okay unless the owner says no. That difference may sound small on YouTube. In real life, that difference can mean the line between lawful carry and a misdemeanor charge. And that is why this fight matters so much. The issue is not whether a private business owner can ban guns. They can. The issue is who gets the default rule. Does the default favor the permit holder unless the owner says no? Or does the default favor the state, making ordinary public-facing businesses off limits unless the owner says yes? Hey, 73% of people watching videos like this aren't subscribed. Don't be part of that group. Join the community of gun owners who want the real update before the rumor mill gets to it. Click subscribe right now, because when this opinion drops, the loudest voices online will not always be the most accurate ones. Now let me tell you what this case probably does not do, because this is the part that shocked me when I saw how many people were getting it wrong. Even if the Supreme Court rules against Hawaii, that does not mean all sensitive place laws vanish overnight. Courts have still treated some places as more defensible than others. In the Maryland case, for example, the Fourth Circuit upheld bans in government buildings, schools, healthcare facilities, public transportation, museums, stadiums, casinos, and places that sell alcohol. So if you hear someone say the court is about to legalize carry everywhere, slow down. That is almost certainly not what is happening. What the court seems to be wrestling with is a narrower but still huge question. Can a state flip almost all ordinary private businesses into off-limit zones by default? That is why this case matters. It reaches the places normal people actually go every day. Have you ever wondered why this fight feels so confusing? Because states learned after Bruen that they might lose if they openly defied the right to carry. So instead of saying no one can carry, they got more creative. They made giant lists. They expanded sensitive places. They treated parking lots, beaches, parks, restaurants, and ordinary storefronts like special zones. In other words, most people think the old fight was about getting a permit. But the new fight is about whether your permit means anything once you leave your driveway. Don't make this mistake. Do not assume a permit gives you a green light everywhere. And do not assume a friendly Supreme Court argument means your state law stopped applying yesterday. Until the final ruling comes down, enforcement risk is still real. So what should you do right now? First, know your own state's carry map, not the meme version, the real one. Second, pay attention to posted signs and business policies. Third, if you travel, remember that another state's private property rule may be very different from yours. Fourth, stop taking legal advice from thumbnail headlines. A title can get clicks. It cannot defend you in court. And here's the part nobody wants to say out loud. Even if the Supreme Court rules the right way on this issue, anti-gun states will keep testing the edges. They may rewrite the laws. They may narrow some bans and expand others. They may shift the language from private property to special use areas or high-risk gathering places. So one win, if it comes, will matter a lot. But it will not be the end of the war over where you can lawfully carry. That means your mindset has to change. Stop thinking in terms of one giant national victory that fixes everything forever. Start thinking in terms of moving pieces. One ruling, then new lawsuits, then rewritten statutes, then more court fights. That is the real game now. This case is moving fast, and when the opinion comes out, the legal picture in several states could change in a hurry. Subscribe now because my next breakdown will cover exactly what the ruling means for permit holders, travelers, and anyone carrying on ordinary private property open to the public. So here's the bottom line. The Supreme Court has not yet issued a final nationwide order wiping out overbroad carry bans, but it is actively reviewing one of the most aggressive post-Bruen carry restrictions in the country, and the justices sounded skeptical in a way gun owners should not ignore. Pause. If the court rules against Hawaii, the biggest impact will likely be on laws that treat everyday businesses like automatic no-carry zones, unless you get special permission first. And if you don't, but to understand that distinction, you could either panic for no reason or walk into trouble thinking the fight is already over. If this video helped you cut through the noise, subscribe and stick with this channel. I know this stuff can feel stressful, confusing, and honestly exhausting, but you should not have to guess whether protecting yourself also puts your freedom at risk. One final simple reminder: laws change, facts matter, and your situation may be different. So always check your current state law and get real legal advice when you need it.